Here are three of the most common misconceptions about workplace rights and laws in California that you need to be aware of, whether you're an employee or an employer. Number one, contracts always determine your rights. Sometimes it's true, and sometimes it's not true. And the most obvious example is this mistake that so many employers make of having their workers sign an independent contractor agreement and assuming that's it. This person is independent contractor, not realizing that the law doesn't completely and fully rely on such agreements. Many other factors matter. So if that worker doesn't fall into the independent contractor classification based on how they work, their job duties, their compensation, the agreement is pretty much not going to matter. The other example is some agreements are against public policy. So even if you get your worker to agree to something in writing where you sign it, they can still come back and say, hey, this agreement doesn't matter. You violated my rights, even though the agreement says that it's okay, my rights wouldn't be violated. So now I can make a claim against you. The most obvious example is that an employer cannot agree in California on below minimum wage pay. So if a worker comes to the employer and says, I really want to work for you for $3 an hour, I really don't mind. I'm willing to sign an agreement that says that I'm okay to work for this wage. Later, that employee can go to labor board or to court and to claim violations of minimum wage ordinances and claim unpaid wages and related penalties. So contracts are important, but they don't always determine your rights or the other side's rights. Misconception number two, the meaning of protected class. Many workers believe that by being quote unquote protected because they are on medical or disability leave or because they filed a harassment complaint, they have some kind of immunity, some kind of diplomatic immunity from being fired. That's not the case. The employer can still choose to terminate you for whatever reason they want. They can even come to you and say, hey, I'm terminating you because you're on leave or because you made that complaint. I know it's illegal. If you want to sue me, be my guest. Being a member of a protected class means that if you're able to prove that you've been retaliated or terminated because you were a member of that protected class, then you may be able to make a case for retaliation, for wrongful termination, and get awarded compensation. So being on disability leave doesn't mean you're untouchable, that the employer cannot fire you. But it does mean that if the employer takes action against you and you're able to prove that that leave was the reason or one of the reasons for terminating you, you may have a case and you may be entitled to compensation. And the third misconception is the meaning of retaliation. Many, if not most people out there believe that if they complain or if they do anything, and in response the employer terminates them, it's retaliation. It might be retaliation in the ordinary sense of the word, but this doesn't make it unlawful retaliation for which you can sue, for which you can file a claim. Only some types of retaliation are unlawful. And in California specifically, in order to make a valid claim for retaliation, you have to show that the underlying activity, your activity for which you were retaliated, was a quote unquote protected activity, such as complaining about discrimination, complaining about harassment, requesting a disability accommodation at work, or requesting medical leave, making certain inquiries about wages, complaining about specific safety violations, complaining about unlawful or even criminal conduct at workplace, reporting fraud and waste in some circumstances. Those types of activities can be considered protected activities, and if the employer takes action against you for engaging in those activities, you might have a valid claim. But let's take an obvious example. If your employer is yelling at you, if he gives you more work than he's supposed to, if he gives you tasks that are outside of your job duties, and then you complain about all that, and the employer fires you for making that complaint, even if you prove beyond any doubt, even if the employer admits, yes, we didn't like that This employee complained about working too much, about us yelling at him. That's why we fired him. This would still not be illegal because those complaints are not protected activities. They're not the same as reasonably and in good faith complaining about unlawful discrimination, unlawful harassment, and all those other things that I mentioned earlier.